Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start. We start with the headlines and a brief overview of the top stories, and then we will dive into the full details and in-depth coverage of each update. In the Haldwani evictions matter, the Supreme Court has given 2 months to the state of Uttarakhand to come up with a rehabilitation scheme for persons to be evicted. The National Commission for Protection of Child Rights has stated before the Supreme Court that madrasas are unsuitable for proper education and have arbitrary mode of working. The top court has observed that rejection of remission must be immediately conveyed to the prisoners to enable them to seek legal aid. The Supreme Court has criticized the Punjab and Haryana High Court and the Punjab government for not reinstating a judicial officer whose dismissal was set aside by the Supreme Court, saying that National Medical Commission is expected to act fairly. The Supreme Court has imposed on it a cost of 10 lakhs for challenging a medical college's approval. The Madras High Court has imposed a cost of 50,000 on the state for appealing against compensation for death of a child in a Sri Lankan refugee camp. The Karnataka High Court has declined to quash POCSO case against a teacher who allegedly took pictures and videos of minor girls while they were changing clothes. The Supreme Court today gave 2 months' time to the state of Uttarakhand to come up with a rehabilitation scheme for persons sought to be evicted by railway authorities in Haldwani. The matter refers to a legal dispute concerning eviction of thousands of residents from a large area of land in Haldwani, Uttarakhand. The land in question is claimed by the Indian Railways, which alleges that people have illegally occupied it. In December 2022, the Uttarakhand High Court had ordered eviction of more than 4,000 families living on the disputed land, many of whom had been residing there for decades. This led to widespread concern and protests as the residents argued that they had legal rights to the land, with some claiming that they had purchased the land or had official documents to prove their stay. The High Court's order was, however, stayed by the Supreme Court in January 2023. Today, the bench of Justices Suryakant, Dipankar Datta and Ujjal Bhaya was hearing an application filed by the Union of India and Railways seeking modification of the court's stay order. As per the Railways, a retaining wall protecting the railway tracks was demolished by the violent flow of Guhala River during last year's monsoon. As such, a request has been made for a strip of land to be made available urgently to facilitate the railway operations. Previously, the top court had stated that the authorities should ensure rehabilitation of people before evicting them. The Chief Secretary of Uttarakhand was directed to convene a meeting with the railway authorities and the Ministry of Housing to devise a rehabilitation scheme. Today, Senior Advocate Balbir Singh, appearing for the state of Uttarakhand, informed the court that steps were being taken in terms of the last order. He requested for 2 months' time to place a suitable rehabilitation scheme. Also, Senior Advocate Colin Gonsalves, appearing for the petitioners, urged that the retaining wall was almost complete now and flooding of the railway tracks was no longer possible. So he stated that not a single person had to be shifted. At this point, Advocate Singh interjected, pointing out that the same is not a permanent solution. Ultimately, the matter was adjourned to enable the state to file a concrete proposal, and interim directions will continue in the meantime. And now let me tell you that the National Commission for Protection of Child Rights has filed written submissions in the Supreme Court expressing concerns about quality of education imparted through madrasas. The statement was filed in the case before the Supreme Court, which is challenging Allahabad High Court's decision to strike down the Uttar Pradesh Board of Madrasa Education Act 2004. In April, the Supreme Court had stayed the High Court's judgment, saying that the decision would impact nearly 17 lakh students. The Commission, in its statement before the top court, has now stated that since madrasas are exempted from purview of Right to Education Act of 2009, all children studying there are deprived of not only formal education in schools but also benefits as provided under the RTE Act, such as midday meal, uniform, trained teachers, etc. According to the Commission, a madrasa works in an arbitrary manner and runs in an overall violation of the constitutional mandate, RTE Act and the Juvenile Justice Act. The Commission has listed 4 key issues, which include number 1, lack of holistic development such as social events and extracurricular activities for experimental learning. Second, a focus on religious teachings with limited participation in mainstream education. Third, teachers appointed by madrasa management not meeting the standards of the Right to Education Act. And fourth, that children missing out on basic amenities and the formal education environment required by the RTE Act. The Supreme Court bench of Justices Abhay S. Oak and Augustine George Massey, while hearing a suo motu case to establish a uniform policy for granting bail to prisoners across India, said that any rejection of remission applications must be promptly communicated to prisoners to enable them to seek legal aid. The suo motu case here was initiated after the Supreme Court recognized that there was a lack of uniformity in the remission policy of different states. The court was informed that more than 50% of prisoners are under trial, some having served more than half of their maximum sentence, making them eligible for bail under Section 436A of the CRPC. Despite this, many remain in jail. Previously in May, the court had directed states, including that of Uttar Pradesh, Jharkhand and Bihar, to provide data on premature releases to amicus curiae senior advocate Liz Matthew. It was revealed that the state of Uttar Pradesh had the worst compliance record. Senior advocate Matthew informed the court that Haryana and Karnataka have largely complied except for a few cases pending approval from the Ministry of Home Affairs. The court, noting delays in compliance by several states, has now issued fresh directives to those yet to submit their reports. It emphasized that any rejection of remission applications must be promptly communicated to prisoners. The court noted that Delhi has taken the official stand that since the Chief Minister is in jail, no cases will be taken. The court said that this issue needed to be dealt with. Also, the e-prison module issue will be taken up on 25th September now. Stay tuned. In the next update, the Supreme Court has criticized Punjab and Haryana High Court and the state of Punjab for refusing to reinstate a judicial officer whose dismissal was overturned by the Supreme Court in the year 2022. In 2022, the Supreme Court had nullified a 2009 order by the Punjab government terminating the officer's services and had set aside the High Court's judgment upholding that dismissal. The Supreme Court had also asked the High Court's full court to reconsider the matter. After this, the full court reconsidered the matter and reiterated its earlier recommendation made in 2009 to terminate the services of the officer. Further, the state of Punjab passed an order terminating services of the officer with retrospective effect from 2009. Considering the application of the officer, the Supreme Court bench comprising Justices Vikram Nath and P.B. Varale has observed that there was no justification for not reinstating the officer once his dismissal was set aside. The court ruled that the officer should receive full salary, including all benefits for the period from April 2022, that is when the date of Supreme Court's judgment was passed, to April 2024, treating him as continuously employed. For the period of December 2009 to April 2022, the court decided that the officer should be awarded 50% of the back wages with all applicable benefits as if he had been in continuous service during that time. The top court has deprecated the National Medical Commission for raising a frivolous challenge to approval granted for expansion of a medical college. The KMCT Medical College in February 2023 was granted approval for an increase of seats from 150 to 250 for the academic year 2023-2024. The approval was granted by Medical Assessment and Rating Board, but in April the same year it was withdrawn. This year in June, the board disapproved the expansion, giving two reasons. First, that certificate of affiliation was not submitted, and second, that the matter was sub judice in the court. The NMC had approached the top court in an SLP against the Kerala High Court, which directed to grant permission to the college filing an undertaking. The court ruled that the case being pending in court should not have been a reason for rejecting the application. If the NMC had concerns, they could have asked the court for clarification. Further, the court said that certificate of affiliation was issued in August 2024. However, the NMC argued that the permission is reviewed annually and the previous approval was for the academic year 2023-24. The NMC stated that since there was no inspection for the academic year 2024-2025, the High Court's order was not justified. The bench of Justices B.R. Gavai and K.V. Vishwanathan of the Supreme Court rejected this argument, noting that the college had been operating for 18 years. It criticized the NMC for making the college seek permission from multiple courts, especially since it was not a new institution. The court said that this was an attempt to harass the college, as the only issue raised was the lack of a certificate of affiliation with no other deficiencies found when the earlier approval was withdrawn. Calling the NMC's petition an abuse of process of law, the court dismissed it and imposed a cost of 10 lakhs. The Madras High Court has dismissed an appeal filed by the state of Tamil Nadu against an order which directed the state to pay 5 lakhs as compensation to the family of a child who died in a Sri Lankan refugee camp. Calling the state's action unpardonable and inexcusable, the bench of Justice R. Subramanian and Justice Victoria Gauri dismissed the appeal and imposed a cost of 50,000 on the state to be paid to the victim child's family within 2 weeks. The court also remarked that when the state government could pay 10 lakh as compensation to dependents of persons who died by consuming illicit liquor, they should not have challenged the order to pay compensation to the child who died due to the collapse of a poorly constructed and poorly maintained wall. During the appeal, the state government had argued that as per the government order, compensation amount was fixed at 25,000 by the state government. The court, however, said that the government order could very well be ignored, especially when the court was determining compensation for death due to state's negligence. And lastly, the Karnataka High Court has refused to quash a case against a drawing teacher of a private school who is accused of recording videos and clicking photographs of minor girl students in the residential school when they were changing their dresses. The Joint Director of the School Welfare Department in December last year had received a complaint, following which a case was registered. The accused stated that the police had seized his mobile phones and then the crime came to be registered. Thus, according to him, it violated the law as the investigation had taken place before registration of the crime. The prosecution, on the other hand, opposed the plea, contending that the accused had indulged in acts which would become an offence under Section 12 of the POCSO Act. The bench perused the material on record and observed that the accused had 5 mobile phones of different brands. All the mobile phones were seized and sent to FSL. Each of the mobile phones had close to 1,000 images and several hundreds of videos. It held that being a teacher, it was indecorous on the part of the petitioner to have allegedly shot the videos and taken pictures of girl children while they were changing their dresses. Justice M. Nagprasanna said that considering the petition or quashing the case before a full investigation would wrongly excuse the alleged illegal activities of the teacher. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.